Let's take a look at Baker versus Carr from 1962, one of the required cases for AP government. If you were to look at a map of any state's legislative districts, you'll notice that some are rather large geographically speaking, and others are quite small. What this reflects is the difference in populations in those given areas. But this hasn't always been the case. Let's take a look at Tennessee, for example. It's the 1960s, and despite years of population shifts, Tennessee's legislative districts have not been redrawn since 1901. And yet, state law required that those legislative districts be redrawn every 10 years after the federal census had been taken, and the legislature had chosen not to redraw them. As a result of years of population shifts, some districts, those in urban areas, contained as much as 10 times the population of other districts, those in rural areas. And yet, they had the same number of representatives. This is the case of Shelby County, which is where Memphis, Tennessee is, which has a very large population. Charles Baker was a voter in Shelby County, and he argued that he and other urban voters were being denied equal protection under the law, which is guaranteed by the 14th Amendment to the U.S. Constitution. As a result of living in a district with a large population, his vote was being diluted when compared to voters in rural districts. Think of it this way: if you lived in a district and there were only 100 voters, then your one vote would have a big impact on the outcome of an election, a 1% impact. However, if you lived in a district with 10,000 voters, your single vote would not have nearly the impact on the outcome of that election. As a result, Baker sues the state of Tennessee, and the defendant in this case, the Secretary of State, Joe Carr, argued that the court has no authority to provide a solution to this problem, if there is a problem, because it is a political matter, and therefore it should be handled by the legislature. It falls outside the court's jurisdiction. The district court agrees with Carr. They dismiss Baker's complaint. They say this is not a matter for federal courts. Baker disagrees, and he appealed to the Supreme Court. In a divisive decision, the Supreme Court ruled in Baker's favor, deciding that the 14th Amendment's guarantee of equal protection under law applied to state legislative districts. Therefore, such cases fall within the jurisdiction of federal courts because they are constitutional questions. The court didn't determine whether or not Baker's vote was diluted, only that he had standing and was entitled to a trial and decision. The case was then sent back to the lower court for review. Let's take a look at the majority opinion as written by Justice Brennan. It is clear that the cause of action is one which arises under the federal Constitution. The complaint alleges that the 1901 statute affects an apportionment that deprives the appellates of equal protection of laws in violation of the 14th Amendment. Dismissal of the complaint upon grounds of lack of jurisdiction of the subject matter would therefore be justified only if the claim were so attenuated and unsubstantial as to be absolutely devoid of merit. Since the district court obviously and correctly did not deem the asserted federal constitutional claim unsubstantial or frivolous, it should not have dismissed the complaint for want of jurisdiction on the subject matter. In other words, he's saying that the Supreme Court is telling the district court this person had a right to come to a federal court and make a constitutional claim. It was not frivolous, it was not unsubstantial, and so the court should not have dismissed the claim. He goes on, the appellants seek relief in order to protect or vindicate an interest of their own and of those similarly situated. The constitutional claim is in substance that the 1901 statute constitutes arbitrary and capricious state action offensive to the 14th Amendment in its irrational disregard for the standard of apportionment prescribed by the state's constitution or any standard, affecting a gross disproportion of representation to a voting population. The injury which the appellates assert is that this classification disfavors voters in counties in which they reside, placing them in a position of constitutionally unjustifiable inequality vis-a-vis voters in irrationally favored counties. We conclude that the complaint's allegation of denial of equal protection is justiciable constitutional cause of action which appellates are entitled to a trial and a decision. The right asserted is within the judicial protection under the 14th Amendment. In other words, claims about representation, unequal representation in state legislative districts are a matter that must be addressed through the Equal Protection Clause of the 14th Amendment. It is therefore a matter for federal courts to examine. Not everyone on the Supreme Court agreed. The dissenting opinion argued that the court's authority possessing neither the purse or the sword, a little reference to Federal 78, only rests on the sustained public confidence in its moral sanction, that they would not overstep their bounds. But this authority is now threatened by its willingness to inject itself into political matters and overturn precedent, in which such issues were left to state legislative bodies. And it expresses concern that the court is now depriving a legislative power, the power to draw legislative districts, from a duly elected state legislative body. But nevertheless, Baker versus Carr is a landmark decision. It established the precedent that citizens have the right to challenge the legality of their legislative districts on basis of the 14th Amendment. Future court cases would reaffirm that the 14th Amendment's Equal Protection Clause applies to legislative districts. As a result, districts now are roughly the same size in terms of the populations that reside within them, and establishes the principle of one person, one vote.